When you think about the laws that govern our lives, you usually picture these giant, heavy books filled with dense text.
Right, or like physical things written down somewhere, a speed limit sign or a zoning ordinance.
Exactly. Tangible, visible rules that just say, do this or don't do that. But what if the most powerful, economy-shaping legal rule in the entire country is, well, completely invisible?
Yeah, it's quite literally a rule made out of silence.
And if this silent rule didn't exist, our entire modern economy, I mean, the next day shipping you rely on, the national grocery chains, a unified currency, it would all just collapse overnight into 50 competing hostile fiefdoms.
It's, the legal equivalent of dark matter. You can't actually see it written in the Constitution,
Yeah.
but its gravitational pull is really the only thing holding the entire national market together.
Which is wild to think about.
Right, because before the Constitution was drafted, back under the Articles of Confederation, states were constantly slapping tariffs on each other. They were blockading ports, starting literal trade wars. The Founding Fathers realized that if states could just wall off their economies, the nation would tear itself apart.
Today, we are taking this notoriously tricky legal concept, this invisible rulebook, and decoding it just for you.
Go.
We're pulling from an incredibly detailed stack of sources today. We have excerpts from an MBE Constitutional Law Prep Masterclass script, and we're cross-referencing that with the MBE Mastery Guide for law students.
It's a great stack.
It really is. So whether you're a law student currently prepping for the bar exam, or you're just insanely curious about the invisible guardrails that keep, like, New York and New Jersey from launching an economic Cold War, this deep dive is your shortcut to being well-informed.
Absolutely.
Our mission today is to master something called the Dormant Commerce Clause, or as law students frantically highlighting their textbooks call it, the DCC.
Yes, the dreaded DCC. So to understand the dormancy part, we have to start with what is actually written down. The Constitution explicitly grants Congress the power to regulate interstate commerce. That's the affirmative power.
Right, the power they actually have on paper.
Exactly. The Dormant Commerce Clause is the negative implication of that written power. It essentially means that even when Congress hasn't enacted any controlling legislation, like even when they are completely 100% silent on an issue, individual states still cannot engage in economic protectionism.
So they can't just favor their own.
Right. They can't use their local regulatory power to wall off commerce and favor their own local businesses at the expense of out-of-state competitors.
I always, I visualize this with a specific dynamic. Think of it like a parent that's Congress and a group of squabbling kids. Those are the 50 states.
Well, like that.
Yeah, so even when the parent leaves the room and the house is totally quiet, the kids intuitively know they aren't allowed to start putting padlocks on the shared toy box to keep their siblings out. The rule exists in the silence.
That paints the picture perfectly. But before we even start analyzing how the states are behaving around that toy box, the sources emphasize a vital threshold check. Law professors call this Step 0.
Step 0. Got it.
Yeah, before you do any Dormant Commerce Clause analysis, you have to ask a couple of fundamental questions. First, is there actually a state or local law affecting interstate commerce? Because if the federal government passed the law, we're in a completely different universe.
Because this doctrine is just about limiting state action.
Precisely. And the second question of Step 0 is just as crucial. Has Congress spoken? Like, is the parent actually silent on this specific subject?
Because if the parent yells from the kitchen, yeah, you can lock your brother out of the toy box, then the rules change entirely.
Exactly. The sources give us a brilliant hypothetical to illustrate this, labeled Hypo 9. Imagine Congress passes a federal statute that expressly authorizes states to restrict the importation of certain types of toxic waste from other states.
So Congress is actively saying, hey, states, you have our permission to build a wall against outside garbage.
Right. Then a state takes them up on it and enacts an import ban on that specific waste. Naturally, an out-of-state waste disposal company immediately sues, crying foul under the Dormant Commerce Clause.
But the lawsuit drops out entirely, right? It just evaporates.
Exactly.
Because Congress holds the ultimate affirmative commerce clause power. If Congress explicitly authorizes the state to build that specific wall, the parent has spoken. The dormancy is gone, the silence is broken, and the state is totally protected.
Spot on. But those explicit permissions are rare. Usually, Congress is completely silent. The parent has left the room, no instructions were given, and the states inevitably start making their own local rules that bleed across state lines. So how do the courts judge those rules?
Okay, let's unpack this because this brings us to the golden rule of our source material. If you take absolutely nothing else away from this deep dive, brand this two-word phrase into your brain. Classification first.
Classification first, yes.
Yeah. The entire doctrine hinges on a crossroads. When a court looks at a state law, they must classify it into one of two tracks. Track 1 is the law discriminatory, or Track 2 is the law even-handed.
That initial classification is everything. The track you choose determines the legal test you apply. And the legal test you apply almost always determines the ultimate outcome of the case.
Let's start with the dangerous road, Track 1. Discrimination. If a law favors in-state economic interests while simultaneously burdening out-of-state competitors, it's discriminatory. Our sources tell us this discrimination comes in 3 specific flavors: facial, purposeful, and practical effect.
Facial discrimination is the easiest to spot. This happens when a state gets blatantly greedy and literally writes the discrimination right into the text of the statute.
Like hanging an outsider's pay double sign on their border.
Exactly. The classic example from the prep materials is a milk tax. A state legislature passes a law imposing a $2 per gallon tax on milk produced in neighboring states, but only a 50-cent per gallon tax on milk produced locally by their own farmers.
Wow. Openly distinguishing between in-state and out-of-state, right there in black and white. Total blatant protectionism.
Which is why states rarely do it anymore. They know it will get struck down immediately. So they get sneaky. Which leads us to the second flavor: purposeful discrimination. Here, the text of the law might look completely neutral on paper, but the actual intent behind the law is protectionist.
But how do courts actually prove that? I mean, lawmakers aren't going to just admit they're breaking constitutional rules.
No, they don't admit it in the law itself, but they leave a paper trail. Lawyers challenge the law by digging into the legislative history. They subpoena emails.
Oh, the emails always get them.
Always. They pull the transcripts from some obscure Tuesday morning agricultural committee hearing where a local state senator pounded his fist on the desk and promised his constituents he would keep out those big bad out-of-state corporate fisheries.
So they find statements showing lawmakers explicitly passed the supposedly neutral requirement just to give local fleets a monopoly.
Right. That hot mic moment, that documented intent, unmasks the law.
Wait, hold on a second. I can completely understand catching a politician on a hot mic or finding a smoking gun email. If they intended to discriminate, they should be penalized. But I really want to push back on this third flavor, the sources list practical effect.
Okay, let's hear it.
If a state writes a law that is totally neutral on paper, and there are no shady backroom emails, and nobody secretly schemed to hurt outsiders, aren't they just passing a normal law? How can a court penalize a state for an accident?
It's a totally valid skepticism, and it gets to the absolute core of why this doctrine is so sharp. The Supreme Court doesn't just care about what a law says. They care about how it operates in the real world, on the ground.
So the actual impact.
Yes. A law can be perfectly neutral on paper, crafted with the best of intentions, but if it creates a reality where locals can easily comply while outsiders realistically cannot, it operates as an invisible tariff. The sources use a fantastic hypothetical about an apple grading system to explain this mechanism.
Okay, so imagine you run a massive orchard in Washington state. You ship apples all over the country.
Exactly. And to do that, you use the widely recognized USDA grading system on all your packaging. It's the national standard. But then a state over on the East Coast passes a new law. The law says all apples sold within our state borders must display only our state's specific unique grading system on the box.
On its face, it sounds totally fair. It says all apples, regardless of origin. And the stated purpose is just consumer protection, preventing confusing labels for grocery shoppers.
It sounds perfectly innocent. Until you look at the actual supply chain. In practical effect, the in-state growers in that East Coast state already use that specific local grading system. It costs them absolutely $0 to comply.
Oh, I see.
But you, the Washington state grower, to sell in this one specific state, you now have to build a new facility, separate your inventory, and completely repackage and relabel a portion of your products at an enormous prohibitive cost.
So the practical effect is that it radically raises the cost of out-of-state apples, effectively handing a monopoly to the local producers by just pricing you out of their market. It's an invisible wall.
Precisely. And because of that devastating practical effect on the national market, the court will rip off the mask of neutrality. They don't care if it was an accident. They force the law down. Track 1, the discriminatory track.
And once a law is shoved onto track 1, whether by face, purpose, or practical effect, it enters a brutal legal gauntlet.
What's fascinating here is just how incredibly harsh the Supreme Court is on economic protectionism. It goes back to that fear of the country breaking apart over trade wars. When a law is classified as discriminatory, the courts label it virtually per se invalid.
Which is such an intimidating legal phrase. It's essentially the equivalent of strict scrutiny, right?
Pretty much.
It means the court flips the script entirely. They look at the state and say, we assume you are guilty of protectionism from the jump. Prove to us you weren't.
Right. The presumption is that the law is unconstitutional, and the state has to climb a near impossible mountain to save it. To survive that gauntlet, the state bears a massive burden of proof. They must demonstrate two very specific things. First, they have to prove the law serves a highly legitimate local objective, usually something vital related to health, safety, or environmental protection.
Economic advantage doesn't count.
Ever.
Which honestly isn't the hardest part. Clever state lawyers can usually point to some plausible health or safety goal. It's the second requirement that is the real killer.
Oh, absolutely. The second requirement is that the state must prove that this legitimate objective cannot be adequately served by any reasonable, non-discriminatory alternative. If there is any less discriminatory way to achieve the safety goal, the state loses. Let's look at the solid waste import ban hypothetical from the prep materials to see how this plays out in a courtroom.
Okay, so a state passes a law strictly prohibiting the importation of solid waste from other states into its landfills. No outside garbage allowed. It's facially discriminatory because it targets out-of-state waste specifically.
So it's virtually per se invalid.
Right. The state gets dragged into federal court. The state's lawyers stand up and say, Your Honor, we have a highly legitimate local objective. Our landfills are overflowing. We are just trying to protect our local environment and conserve space for our citizens.
The judge nods and says, protecting the environment and managing landfill space is a completely valid interest. But is slapping an embargo on out-of-state waste the only possible way to achieve that? And this is where the fatal flaw is exposed. There is absolutely a non-discriminatory alternative.
The alternative is so obvious once you see it. The state could simply charge a flat, equal per ton disposal fee on all waste entering the landfill, regardless of where it originated.
Exactly.
If you genuinely want to reduce garbage to save space, tax all garbage equally. Because that perfectly neutral, non-discriminatory alternative exists, it proves the import ban wasn't really about the environment, it was about shifting the burden to outsiders. The state's law fails.
The bottom line for Track 1 is that discriminatory laws almost always fail. The Supreme Court simply will not tolerate states acting like hostile foreign nations to each other.
Here's where it gets really interesting, because states aren't powerless. The Constitution gives them broad police powers to protect the health and safety of their citizens. They have to be able to run their local governments, pass fire codes, and set traffic laws. So what happens when a state passes a legitimate, perfectly normal safety law that genuinely applies to everyone, but it just so happens to annoy a massive interstate corporation?
That takes us off the harsh, unforgiving road of Track 1 and puts us squarely onto Track 2, even-handed laws. These are laws that regulate evenly and only incidentally burden interstate commerce. And the legal test completely flips. We don't use that brutal, virtually per se invalid standard. We use something called Pike balancing.
Named after a famous Supreme Court case. Under the Pike balancing test, the law is actually upheld unless the challenger can prove that the burden on interstate commerce is clearly excessive in relation to the local benefits. Notice the massive shift in leverage there.
It's huge.
The presumption has flipped. The law is presumed valid. The burden is no longer on the state to prove it was their only option. The burden is on the challenger, the angry out-of-state business, to prove the law is excessively, ridiculously burdensome. It's a highly state-friendly test.
It really is.
Yeah.
Let's compare two vivid scenarios to see how this balance actually feels in practice. I want you to imagine you own an interstate trucking company. Your fleet drives from New York to California every single week.
Okay, scenario A, the mud flap. You're routing your trucks through a state in the Midwest. That state just passed a law requiring all commercial trucks operating on its highways to use a specific type of curved contour mud flap. It's a proven safety measure to prevent rocks and debris from kicking up and shattering the windshields of passenger cars.
And crucially, it applies equally to all trucks, in-state, out-of-state, it does not matter.
But you, the interstate trucking company owner, are furious. You have to spend thousands of dollars replacing the standard mud flaps on your entire fleet just to legally drive through this one state. You sue, claiming this is an illegal burden on interstate commerce.
Under Pike balancing, you will lose. The law survives easily. The state has a highly legitimate safety interest in preventing fatal highway accidents. The cost of compliance is certainly an annoying financial burden on your interstate trucking company. But is spending a few $1,000s on mudflaps clearly excessive compared to saving human lives on the highway? No.
The courts have consistently held that mere cost and operational inconvenience don't make a neutral safety law unconstitutional.
Exactly.
But let's look at scenario B, the clearance bar. What if this same Midwestern state passes a law requiring a bizarre, custom-designed, cab-mounted metal clearance bar on the top of every single truck? No other state in the entire country uses this bar.
Right. Highly unusual.
The safety benefit is, at best, incredibly marginal. Maybe it prevents one minor scrape a decade. But to comply, you, the trucking company, would have to completely retrofit your entire national fleet. We are talking millions of dollars taking trucks out of commission just to cross through this one single state's borders.
Now we have a different outcome. Even under the very lenient Pike test, the regulation is still even-handed. It applies to everyone on that highway. But here, the burden on the national market is completely disproportionate. You're forcing entire national shipping fleets to spend millions to accommodate one state's quirky, unproven rule, and the local safety benefit is practically non-existent.
So the cost vastly outweighs the benefit.
Yes. In this rare scenario, the burden on the national economy is clearly excessive in relation to the putative local benefits. The law fails. We connect this to the bigger picture. The Dormant Commerce Clause isn't designed to strip states of their sovereign right to regulate their own territory. It doesn't penalize states for exercising ordinary authority. It just stops them from accidentally gumming up the gears of the national economy with disproportionately burdensome red tape.
We now have two perfectly laid out tracks. Track 1 for discriminatory laws, which face the strict, virtually per se, invalid test. Track 2 for even-handed laws, which face the lenient Pike balancing test. Seems like a clean, logical framework. But when law students sit down for the bar exam or when high-paid lawyers go to court to argue these massive corporate cases, there's one fatal trap they constantly fall into.
So it is the single biggest mistake you can make when analyzing this doctrine. It's an analytical train wreck.
So what does this all mean? According to the MBE Mastery Guide source, the absolute worst thing you can do is apply Pike balancing to a discriminatory law.
Exactly. Let's say you're looking at a state law, and you correctly identify that it is discriminatory. Maybe it's that tax credit we talked about that goes exclusively to in-state manufacturers. But then, instead of applying the strict Track 1 standard, you drift into ordinary Track 2 balancing.
You start arguing, well, the state has a really strong interest in creating local jobs, so let's weigh that benefit against the burden on the out-of-state competitors.
If you do that, you have already lost.
You are bringing a knife to a gunfight. You are fundamentally applying the wrong legal test. You're using a lenient test instead of a strict one. You are putting the burden of proof on the wrong party, making the challenger prove it's an excessive burden instead of forcing the state to prove there was no other alternative. You are literally asking the court the wrong question.
The Supreme Court treats protectionist laws vastly more harshly than neutral safety regulations. If you mix the tracks, you will fail the exam, and you will lose your case in court. The classification step determines the test. Do not mix them up.
To help you avoid this trap, the sources outline a quick mental checklist, a litmus test for protectionism. When you are evaluating any state law, ask yourself this simple question. Does this law make it more expensive or difficult for out-of-state businesses to compete, while simultaneously making it easier and cheaper for locals?
It's a great question to ask.
If the answer is yes, and that disparity isn't justified by some obvious neutral safety alternative, you are looking at economic protectionism. You are looking at a law that belongs on Track 1. Armed with this litmus test, you now have the key to unlocking how interstate commerce actually functions in this country. Let's recap the core takeaway here.
Good idea.
The Dormant Commerce Clause exists to protect the national market structure itself. It doesn't exist to protect individual businesses from having to pay for expensive mudflaps or comply with local fire codes. It exists to ensure we have one unified, thriving economy rather than 50 competing fiefdoms trying to tear each other down.
Beautifully said.
By remembering to ask classification first, you can instantly tell if a state is engaging in a retaliatory trade embargo that will be struck down, or if they're just passing a normal, everyday safety regulation that will be upheld. You take the invisible rules of the dark matter and you give them structure.
This raises an important question, though a final puzzle for you to mull over as we wrap up. We have spent this entire deep dive looking at what happens when a state acts as a regulator. They are the referee, standing on the sidelines, making rules and laws for the private market. But our source material leaves us with a fascinating hint about an upcoming topic called the market participant exception.
Ponder this. What happens if the state isn't the referee making the rules, but is actually a player on the field?
Right. What if the state government itself is the entity buying tons of concrete for a highway project, or selling timber from state lands, or hiring construction workers?
Does this invisible rulebook still stop a state from favoring its own citizens when the state is spending its own taxpayer money? It's one thing to tell the kids they can't lock each other out of the shared toy box. But what if one of the kids bought the toy with their own allowance? Do they still have to share?
It is a completely different application of the doctrine, and it challenges everything we just established. Keep an eye out for how that exception twists the rules.
Thank you for joining us on this deep dive. You are now armed with a powerful new lens for viewing the laws around you, the national economy, and the invisible forces that shape our everyday lives.
Until next time, keep looking for the rules written in the silence.